Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. I want to address with you a memorandum decision and order in a federal case involving a gentleman who lived not far from where the Idaho 4 events occurred. And this case discusses many of the issues that are relevant in Mr. Kohberger's state case, everything from the desire for a Franks hearing. The court here goes over the 5 elements of what a defendant must prove in order to succeed on a Franks hearing, talks about the alternative remedy of a motion to suppress, and then there's also the issue of confidential informants that are thrown in here. It is a 27-page memorandum and order, U.S. versus Manuel Philip Villalobos. This order is dated March 31st, 2023. It is 27 pages. I have provided a link for you so that you can pull down this memorandum and order and read it for yourself. But basically, this situation involving the defendant here is in federal court because he was charged with several violations of federal statutes. And it began with a dispute with his stepmother, who apparently there were some bad feelings between the two, and it escalated to a very large extent. In page 1 of this filing, the judge states that in his motion for discovery, Villalobos asked the court to compel the government to reveal whether any informants were involved in his case. The government replied that no confidential informants were utilized in this case. That was their response in discovery. Then there's a footnote here at page 1 saying that because his brief in support of this motion is 24 pages in length, 4 pages over the limit, he asked for leave to file excess pages. He asked for permission. That's what leave is. The government has not filed a response. Good cause appearing. The motion for excess pages is granted. There was a similar issue that was raised by the judge himself, Judge Hippler, in the Idaho 4 case that Mr. Kohberger had impermissibly gone over the limit for the number of pages in one of his filings, and the court reminded all that there are local rules, just like there were local rules here in federal court that this district court judge is referencing, that you cannot go in and file hundreds of pages or an unlimited number of pages. There is a limit, and you have to ask for permission in order to file a paper that goes over that limit. If we go on to page 2 and thereafter, you'll see that what had happened here is that there was some bad blood between the defendant and his stepmother. Bobby Ann is her name. And he published some things on his Facebook account that had photographs of an AK-47 and concerns about trespassing. And Bobby Ann felt that this was directed toward her, so she contacted local authorities and the situation just blew up. And I will allow you to take a look at what's there so that you can kind of see how it went from a dispute with a stepmother to being charged with several federal crimes. Page 10 cites to what happened here. The offense here, he was charged with being a felon in possession in violation of 18 U.S.C. 922 G1 and 924A2. The following week, a grand jury indicted him, and this is federal because this is a federal statute. Next paragraph, grand jury returned a superseding, that means a second indictment, that added 4 more charges of assault upon a federal officer, 4 counts of use of a firearm during and in relation to a crime of violence, 1 for each of the assault counts, and a charge for possessing a silencer. And the pages that come before will go into further detail of what that's all about. Then there was another superseding indictment that was issued. The charges remained the same. This document, which is document number 28 on the court docket, is what the operative indictment, that means the indictment that the government's riding upon to charge and to bring this defendant to trial. Now, if you go to page 13, you will see the legal standard for a Franks hearing. It says, at a Franks hearing, a defendant may challenge the veracity, the truthfulness, the propriety of an affidavit underlying a search warrant. So it's the affidavit for the search warrant that is front and center in a Franks hearing, not the fruits of the search warrant, not the items that were seized. It is the affidavit that was brought to the judge, that was relied upon to enter the order authorizing the search or the seizure or both. And then he cites two, Franks versus Delaware. In Franks, the Supreme Court held that the Fourth Amendment, which does a lot of things, including that it makes illegal searches and seizures improper. In Franks, the Supreme Court held that the Fourth Amendment to the United States Constitution requires an evidentiary hearing if, quote, the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included in the affiant in the search warrant. So if the affiant, if the law enforcement official who's signing the, for example, affidavit of probable cause that then goes to the judge, that you get a hearing, the defendant makes a substantial, so the defendant does not just produce a little bit of evidence, a substantial, this is how high this burden is, substantial amount of evidence is required to make a preliminary showing that the false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause. At the bottom, you'll see just how high this burden is. There's 5 elements. This is a 5-part test. You can get 1, 2, 3, and 4, and if you miss out on 5, you don't get the Franks hearing. The court says here, in order to obtain a Franks hearing, the defendant's motion must meet 5 requirements. Number 1, the defendant must allege specifically which portions of the warrant affidavit are claimed to be false. 2, the defendant must contend that the false statements or omissions were deliberate or recklessly made. 3, a detailed offer of proof, including affidavits, must accompany the allegations. 4, the veracity of only the affiant must be challenged. And 5, the challenged statements must be necessary to find probable cause. So this shows why Franks hearings, number 1, are rare, and decisions to throw out warrants are even rarer still. Because warrants, as this court talks about, that a judge signs is presumed to be correct. So also have to get over that presumption that the judge erred in making that warrant. Finally, I'm going to direct your attention to page 27. This is the end result. You can read the preceding pages to see how the court got here, but the court hereby orders, number 1, the motion for discovery is granted. The government has provided a sufficient answer, and that is with respect to the questions regarding the confidential informants. Number 2, motion for an evidentiary hearing and to suppress is denied in part as it relates to the request for a Franks hearing, so he's not getting his Franks hearing. The remainder of the motion, this is to suppress the evidence, not the Franks hearing. The remainder of the motion remains under consideration. The defendant may challenge the search if he so desires at the upcoming hearing, but the testimony and evidence may not include challenges to the veracity of the affidavit in support of the warrant. The court will coordinate with counsel in the near future regarding certain organizational aspects of the upcoming hearing, and this is signed by District Court Judge, the Chief U.S. District Court Judge, David C. Nye. If you would like to review this document in full, I've provided a link, but the bottom line here is that Mr. Kohberger, as do all defendants, bear a very high burden to even get a Franks hearing, and a higher burden yet to get a warrant thrown out because of the elements that you must prove in Franks, 5 parts, all 5 must be proven to get the relief that you're seeking. And also because a judge who signs a warrant finding probable cause, there's a lot of respect given to that judge's decision. So you need to also overcome that barrier. But the good news for Mr. Kohberger is even if he does not get the Franks hearing, or even if he gets the hearing and he doesn't overcome his burden at hearing, there's still the motions to suppress some of the evidence that we believe is also in the Franks hearing. In the last couple of IndieZone episodes, we addressed the fact that Judge Hippler referenced suspect vehicle 1 in a footnote of his November 22nd, 2022 order, 2024 order, ordering that the motion be resent to the court because it was not in proper form. He referenced suspect vehicle 1 there. There's also a lot of references to the IgG DNA evidence. So even if Mr. Kohberger, if this is what he's looking to suppress in the warrants, is not successful, there's still the motions to suppress those matters. And we can expect a very fierce battle at the upcoming January 23rd and, if necessary, 24th hearings on those motions and responses from both sides. This will now conclude this episode of the IndieZone. As always, please like, subscribe, and comment. Your comments are very much welcome and appreciated. Thank you.